What we are going to discuss is Indian Constitution and human rights perspective. I don't need any introduction, right? So I will straightway go to the topic. Okay. So when you talk about the Indian Constitution, it is a very important document. We call it the fundamental law of the land, right? And we also try to look at fundamental rights, which are basically the fundamental law of the land, and similarities between fundamental rights and human rights. So you see that in India, human rights has a historical root, and it is rooted in the very Indian belief, Indian faith, Indian philosophy. And when you talk about the Vedic civilization is a synthesis of different culture and different religion. So we have Dharmasastras initially. So that is basically a Hindu way of law, and it is important to understand what is Hindu way of law. And let me tell you that here it should not lead to aberrances to another religions or even different like ethnicity, people from different ethnicity. But here we talk about the Hindu way of law. That is basically way to look at. Execution of law, and that too from very way of Hindu. So we talk about Dharmasastras, like Dharmasastra is a commentaries of code of conduct, code of law in India. So Dharmasastras maintain that there is the independence of judiciary in India, and executive is always separated from judiciary. So now we get to see that we have three organs of the government. We have executive organ, legislative organ, and judiciary organ. And we actually realize the independence of judiciary and that to implement it in real sense. But here, what we actually see that this is not something very new. So this is there since the codification of the first law, that Dharma Shastra, where it is mentioned that judiciary is independent from the executive, and kings as well as the citizens are subordinated to the law. So when we talk about the king is not above law, and that is somehow different from the Western way of legislatures or understanding the human rights, or you see the natural rights. So we talk about divine origin theory in West, where we see that king is bestowed upon certain power, and which made him above all and above human being. So he is treated as a god, and his rule is also such that violation of such rule will actually lead to punishment or even taking away of life. So you see that kind of belief system is not relatable to Indian tradition, because we do not believe in the divine origin of law or divine origin rights of the king. So we see that kings and the executive is subordinate executive, the very executive who is actually administering the country, subordinate to the law. And Dharma Shastra is also one commentaries who will not confer the status upon the king about how to carry out the conduct. But Dharmasastras are there. Dharmasastras are basically codify the law and recognize the king that okay, he is eligible to rule. So in that way, we see that the Hindu way of law has strictly maintained that independence of judiciary. We also have Ananta Pitaka, Vinaya Pitaka. We have Buddhism. In Buddhism, we also have non-violence in thoughts and the deeds. So these are rooted in the Indian tradition. Okay, you say actually that in Vinaya Pitaka, it is said that prince and private citizens are submitted before the law code. The same thing which I have said, that the citizens and kings are subordinated to law. And you see that Rig Veda, that is also another scriptures, have spoken about three civil rights: Tana, Sriddhi and Jivasi. So when you talk about this Tana, Tana means body. So it is about right over our body. Sriddhi is about shelter, so right over our dwelling. houses, and also Zivasi. Zivasi means life, that is right to life. So that Rig Veda speaks of three very important rights, that civil rights. These are civil rights. You see, there are also distinctions between civil and political rights. Civil rights are there, which actually made our life easier, and also made to give us a dignified entity. But when you talk about the political rights, it is much more relatable to political organizations. And also you talk about right to assembly, right to contest election, right to vote, right to petition. So there is a distinction between civil and political rights. So we talk about those three important civil rights mentioned, about which we found in the Rig Veda, that is Tana, Siddhi, that are Tana, Siddhi, and Jivasi. Those are the three very important rights. Then we talk about the Kautilya's Arthasastra, that is also another treatise. So in Kautilya's Arthasastra, we actually see that there is a mention about happiness of the subject lies in the happiness of the king. And Mahabharata also propagated that whenever there is an oppressive king, so there are also instances of revolt against the king. So you see that Vedic culture has already spoken about mass welfare, public welfare, and that is also much embedded in the concept of Vasudhaiva Kutumbakam, that we talk about universal brotherhood, and that is also enumerated in our foreign policy. So, and we embrace it. Our foreign policy embraced that Vasudhaiva Kutumbakam, and the very nation India is known for that philosophy, embracing that philosophy. Right, and then we talk about some of the classification of human rights. So, in this very slide, I'm going to discuss briefly about some generation of human rights. Okay, so we talk about human rights. You have a fair idea about human rights by now. So you see that these are certain claims, right? These are certain claims which we can have to live a dignified life, and these claims are actually inherent in the nature. And we also say that this might be moral claims. These claims are moral claims also, when you try to relate those claims with historical tradition, customs, etc. But when you talk about those claims, these claims are also uh, available for all, in relation to all, in the sense that everybody can make those claims of human rights, irrespective of their status, irrespective of their ascriptive identities, they can make those claims. Now we see human rights are different from the privileges. When you talk about the claims, claims are always different from privileges, because privileges are some of the entertainments. We may also say that these claims are also entitlements, but this will not make us superior from someone else. This will make us equal among all. Hence, we talk about those rights which are very, very important. These claims are very, very important. These are our entitlement to live a free life, to live a dignified life. Okay, so when we talk about those first generation of right, so we actually see in the first generation of right, this right actually contain civil and political rights. Okay, this right, as I have already told you, civil rights, these are the very important right to live a dignified life, right to life, right to liberty, right to privacy, right to own property, right to have free trial, and right against torture and inhuman and degrading act. Then you see right to form a family, freedom of expression. All these are civil and political rights, and there is also a distinction. We usually distinct civil rights and political rights differently, but civil rights are different from political rights. Okay, these are first generation of right, because those rights actually emanates during 17th and 18th century during this Renaissance and Reformation movement, when the evolution of state usually occurred. The state was formed, state also evolved. Right, state was evolved. State is a political organization, and earlier we only had a society. So there is also primitive society. From primitive society to different stages, state has evolved, and with the evolution of the state, we also make certain claim to have that dignified life, and rights are the product of those demands, those claims, you might say. So you see that first generation of rights are basically civil and political rights. Then we have some second generation of rights. Those rights are originated during Russian Revolution 1917, the Bolshevik Revolution, and Paris Peace Conference 1919. You actually see that there are some milestones to define the human rights, to understand the evolution of human rights, and that evolution will help you to better understand and comprehend the human rights. So if you look into those milestones, like we have the first generation of human rights, the second generation of human rights, and the first generation of human rights situation were different. So there were also struggle for universal adult franchise, there was struggle for rights of the women, even to make themselves free from the solitary confinement. And in the second generation of human rights, we get to see the importance of the cultural and economic rights. And milestones are also set. You see the Bolshevik revolutions and the situation during the Tsar Nicholas, the kind of that inflations and shortage of food supplies, and also concentration of land, labor, capital, as well as entrepreneurship in the hands of the capitalists. That has actually lead to a revolution by the proletariat class against the bourgeois class, against the minority class, and lead to bloodshed also. So that lead to the realization of the importance of economic right, because you see that along with that autocratic terrorism, famine, shortage of food supply, starvation also occurred, and lead to those second generation of rights. So it emphasizes on right to work, and apart from right to food, shelter, clothing, right to adequate standard of living, which is important, right to social security measures. So social security measures also become very important, as well as right to mental health is very important. That also came during that period of time. Right to mental health also came into being. It is related to right to physical health and mental health, equivalent to economic, and you see this cultural right. Then we have the third generation of the right. Okay, one more thing I actually forgot to tell you regarding this ILO, that is International Labour Organization. That is also another milestone which set up in 1990s. Okay, in 1919 we have International Labour Organization set up, and that organization is based on the realization of the protection and promotion of labor rights. So basically, it was set up to promote and protect the labor rights, promote their rights, their material development, their spiritual development. So when we talk about their rights, they also said that the labor are not to be treated as a commodity, and they have every right to have that spiritual development, and irrespective of their aesthetic identity, they can also possess the property. So we have certain distinctions in the society also right from the very beginning, and in each society we get to see some distinction on the basis of the occupations. And India is also not apart from that distinctions. In different societies, that distinction on the basis of occupations or holdings are being made. Now we are also trying and striving to equalize those distinctions. So we are at a place where we are trying to equalize those distinctions, distinction based on the caste, distinction based on the class. That is also based on certain occupation, right? Occupational status. So that is a right to equality, and a very civil and political right. So right to equality, right to liberty, civil and political rights. We have third generation of right. Third generation of rights are known as collective rights or modern rights. These rights are basically right to self-determination, right to peace, and right to development. Very important right. You talk about right to self-determination. So you see that each and every community has the right to determine their political organizations and right to pursue their own socio-political and economic development. At the same time, right to development is very important right that every community can mobilize the resources for themselves and they can develop themselves. It is about communities trust on mobilization of the resources, and right to peace is also very important. Right to peace, it the realization of it happened after Second World War. First World War and Second World War, that actually lead to the you say loss of human life, life. You see, many military and civilians were died of starvation during the post-war period also. Apart from loss of life during the war, during post-war period also, there was loss of life due to starvation, due to even poverty, due to diseases. So that horror of the war had made us feel that there has to have another generation of right, and we also stress upon the right to peace. Okay, so like that way we have classified this, right? Moving on to next, we have some distinctive features of human rights and fundamental rights. So fundamental rights are the very law of the land. So constitution in the law of the land, and fundamental rights are inherent in the constitution. It is enshrined in the part 3 of the constitution. Right. So yesterday you learned about human rights principle, right? Principles of human rights. So those principles are somewhat regarded as the very basic features of human rights. So you see that human rights are inherent in nature. You see, these are inherent in nature. So these are certain claim, as I have already told you, that human rights are certain claim, and then these are fundamental for its existence. So in the sense that nobody can take away these human rights at the same time. So these are claim, these are natural claim. That you can make. These are inalienable in the sense that nobody can take away, and these cannot be abrogated at the same time. And also, you say it cannot be transferred from you to another being. So you have your own set of rights, another human being has own set of rights. So your rights cannot be transferred to another one. So hence human rights are inalienable. Then also we said that universal. Universal is another character, another feature of human rights. So universal in the sense that the human rights are for all. This is not meant for one category of people. These are not privileges. So the rights are universal irrespective of caste, class, then race, ethnicity, place of residence, place of birth, etc., etc. Then we talk about the interrelatedness and indivisible nature of the human rights. So when we talk about the interrelatedness, you see that if one right is violated, it has an impact on the other right. So all rights are relatable. So that is very important feature of the human rights. So you are avail one set of rights, you are not being made to avail another set of rights. That means you see that violation of one set of right will also lead to violation of other set of right. So the rights are interrelated and they are indivisible in the sense that you cannot divide those rights. Then we have the salient features of fundamental rights. So if you look at the salient features of the fundamental rights, you see the very first feature will tell you that fundamental rights are integral part of Indian Constitution, right? Very integral part of Indian Constitution, and nobody can abrogate that right. Nobody can take away that right. And even if there is a provision of amendment, fundamental rights could be amended also. But you see. That amendment has to be by due process of the law, and amendment cannot alter the whole structure of the constitution. Okay, then you see that most rights are comprehensive and detailed. It is elaborated and illustrated detail, and we also have negative and positive variety of the rights, there are certain rights which are of negative order, which also put a restraint on the state to prohibit in order to create social harmony. And there are also certain types of right which are of positive variety, in the sense that those rights will create condition among the citizens to live in harmony. Okay, so we have a negative and positive variety of rights. Then we have seen that all rights, all fundamental rights are justiciable, in the sense that these rights are enforceable by the court of law. Then fundamental rights are restricted by nature, restricted in a sense that these rights are not absolute. Whenever there is an emergency, you see the rights can be suspended also. And you cannot even claim that your rights is above someone else's right. So you see that it is restricted by nature. Even there are some reasonable restriction imposed on a fundamental rights, reasonable restriction imposed on a freedom of speech. Limitation is there in your movement, although you are granted that freedom, you are given that freedom, but certain limitation, certain reasonable restriction is being imposed to realize that fundamental right, to even to avail that universal character of that right, so that everybody can avail it. Okay, and suspension of the right usually happen during the emergency. And there are certain rights which are meant only for citizens, like Article 15, we talk about equality before law, that is meant for citizen, and public employment, that everybody is supposed to get a public employment irrespective of the caste, creed, that place of residence, are meant for citizen. Article 19, freedom of and no, sorry, these are for all. Sorry, these are for all. We actually see Article 15, 16, 19, and 29 are uh, um, these are for all, and there are certain rights which are only for citizens. And then we actually see fundamental rights are also amendable. Okay, as I've already told you, I'm not going to repeat it at all. So I'll come later to the citizen only right, because there are certain unenumerated rights also which are there in the constitution apart from the fundamental rights. Those came by various legislations, but those rights are not enumerated in the constitution. So you also need to know about those very rights. Then we talk about uh, uh, the Universal Declaration of the Human Rights. When we try to equate fundamental rights with the human rights, you actually see certain developments and historical trajectory. So it will see, I'll come back to these similarities and distinctions later on. So we will actually see the historical trajectory of rights in India. So there we will actually find that what leads to the demand of fundamental rights is very important. Okay, so we talk about the British rule, deplorable social condition, cruel nature of the country, and exploitation of tenants by the landlord. These are the conditions which led to the fundamental rights. First, you see this the British rule, the racial discriminations, and also we talk about humiliation of Indians, and the social deplorable condition of women, and also this people from the Harijan caste, like Siddhil caste. Harijan word is not to be used now. So, Siddhil caste, we had also untouchable at that point of time. So, all this actually lead to demand for fundamental rights, laid the foundation of fundamental rights, because you see that there are some milestone we have found Swarajya bill that paved the way for constitution making, and then we also talk of Indian National Congress that demanded the declaration of fundamental right in constitutional framework. So you actually see that there were lack of civil and political rights during British period, and social condition are deplorable, and nature of India is, you see that there are multiplicity of languages, multiplicity of religions, multiplicity of ethnicity and cruel nature of the country also lead or result a different variety of rights. The demanded set the foundation for the demand for different variety of rights, and also exploitation of the tenants. You see that period of time. If you look into the impact of British rule and also the rise of nationalism in India, so you get to find that that is one reason's exploitation of tenants by even the landlord that lead to this rise of nationalism, rise of movement. So everything actually lead to demand for fundamental rights. And Motilal Nehru Committee report is also very important because it has enumerated certain rights. Not only enumerated importance of the rights, certain rights have been enumerated in the Motilal Nehru Committee report, like you see right to education, right to freedom of speech, right to hold arm, then right to equality, and right to have free trial. So, like that, a certain set of rights were already mentioned in Motilal Nehru Committee right, and that has also set the foundation of fundamental rights in India. Then Karachi session of the Congress adopted a detailed program of fundamental rights and emphasized that fundamental rights to be included in the Government of India Act. And then Tezpur Committee report, which is also important, that also emphasize upon the need for fundamental rights. Then moving on to the fundamental rights itself, we have come to learn about those features and distinctive characteristics of human rights and fundamental rights. Now we will be looking into these fundamental rights. We see that is a guaranteed under Part 3 of the constitutions, and we see this constitute article is 14 to article 35 it said. Actually article 12 to 35, somewhere it is mentioned article 12 to 35, or you see 14 to 32 again. So you see that right to equality is the very first like fundamental right. There are six rights. We have right to equality from article 14 to 18, right to freedom article 19 to 22. Then we have right against exploitation mentioned in article 23, 24, right to freedom of religion, which is mentioned in article 25, 28. Cultural and educational right is mentioned in 29 and 30. Then also we say right to constitutional remedies are mentioned in article 32 and 35. So, and another right, right to children education, child education, is a new human right which is included in the Constitution by 86 second Constitutional Amendment Act in 2022. So it's important accordingly. Then we see right to equality, the very first set of right from 14 to 18. So what is equality is very important to understand because it stems from the very understanding of the fact that we human beings are not equal. We are unequal, right? We are unequal in terms of our physical strength. We are unequal in terms of our intellectual capacity and strength. So there is inequality, and we are talking about equality. So we see what kind of equality we are talking about. We are actually talking about equality of conditions here. We are also talking about the equality of outcome. When you actually create an equality of condition, then only equality of outcome can be possible. So here we will look into the comprehensive definition of equality given by Brian Turner. So Brian Turner has given us a very well conceptualization of equality, and he mentioned about equality in terms of four characteristics that all men are fundamentally equal in person, although we live in an unequal state, and inherently also we see we have unequal characteristics and traits, but we are fundamentally equal. All must have equal opportunities and equal conditions, and that will lead to equality of outcome. So here we also talk about positive and negative equality. So here in Constitution also we have emphasized upon two very form of equality. One is equality before law, and another one is equal protection of law. So when you talk about this equality before law, that is basically negative concept, and equal protection of law, that is positive concept. When you talk about the equality before law, that is meant that everyone is supposed to be equal, and state should prohibit discrimination in terms of caste, class, creed, ethnicity, place of birth, place of residence. So here you see the state should prohibit discrimination. So as it is mentioned that state should prohibit discrimination, we see that it is negative in nature, and equality before law is negative in nature. Then you have equal protection of law. Equal protection of law is positive concept, means state should provide opportunities to public employment to all, irrespective of caste, creed, birth, and then place of residence, place of birth, etc., etc. So you see that a negative and positive concept could be also relatable, as we have already told you that rights are of negative variety and rights are of positive variety, and at the same time we also say that there are certain rights, like we see uh, that right to equality, it is also had that same, you say, variety, that positive and negative element. So we see that Article 15 usually talks about the prohibition of discrimination. Article 16 refers to equality of opportunity in matters of public employment. Article 17 emphasized upon abolition of untouchability. Article 18 emphasized upon abolition of titles. Okay, so here you see that abolition of untouchability is a negative right, and abolition of title is also, you see, this negative right. So absence of privilege is very important for prevalence of equality. So you see here, I would also like to bring in the concept of liberty, because liberty and equality goes hand in hand. But at the same time, we also see that many people said that liberty, excess of liberty, lead to also lessening of equality. So where we give too much emphasis upon the liberty, equality cannot prevail. So in that case, we could also see that there are some self-regarding action and other regarding action, which are often mentioned by political scientists and experts. There are certain actions, self-regarding action, right? You see, right to expression, right to opinion, okay, right to religion, right to conscience, are self-regarding action. Self-regarding actions can be restrained and regulated by self. There are also other regarding action over which a state can take some action. State can, political organization or state or government can take some measures, take some actions. So here in terms of equality, we also get to see that a state can create equal opportunity, take some measures, also adopt some legislations through which equal opportunity in matters of public employment could be availed, and also in relation to prohibition of discrimination, state could also go to adopt this positive discrimination if necessary, to create that egalitarian state and create equality for all. And then abolition of untouchability, which is already been done, and it is by that enactment of Untouchability Prevention Act 1955, which was later renamed as Civil Rights Act 1955 only. And then we see that abolition of titles, there are certain decorations. You know about those decorations. In 1954, we had certain decoration and four kinds of decoration. Like we have that Bharat Ratna, Padma Bhushan, Padma Vibhushan, Padma Shri. These are certain decorations. Whether those decorations should be there or not is a question now. So Acharya Kipalani has said that if you are making those decorations, you are actually availing certain privileges for certain section of the people, and hence it is to be abolished. Lot of debate and discussion have been happened, and that's why I have told you that there is a controversy over these decorations, and government of India introduced those decorations. Those were also taken away during Janta government, which were restored by Indira Gandhi government again, said that there should be some titles, and these are of academic distinction and military distinctions, and these are special privileges. So you actually see that when there is a special privilege, there cannot be liberty for all. That was a kind of impression that when there is a special, like, privilege for certain section of the people, there cannot be liberty for all. But now you cannot relate to those titles and the decorations, because these titles are important and some distinction are given to people of military, like, achievement, for military achievement, for academic achievement. Okay, and so now it is instituted, now it is availed. But there was a controversy regarding this also, regarding the privilege, matter of privilege. Then we have the right to freedom. Right to freedom is very important. You see the freedom of speech and expression, freedom of assembly, freedom of association, freedom of movement, freedom of resident and settlement, freedom of profession, occupation, trade and business. So initially we had seven freedom, now we have six freedom. You see, 42nd Amendment has abolished right to acquire, hold, and dispose of property. Okay, so we actually see right to freedom. It's very, very important to understand the freedom. What do you understand the freedom? Freedom means absence of any restraint. That's how we understand absence of any restraint, even from the state. So it is also connected to the political system where you are inhabiting, where you are locating yourself. So the political system, the political organization has also something to do to avail those freedom. You see that certain claims are always there. We can take those claims by very nature. So freedom of speech and freedom of expression. So to what extent we can have a claim over that freedom of, like, speech and expression. So there are debates of different variety. We say on freedom of speech and expression. So that right of praise, and also you talk about the hate speech now in online. They define freedom of speech differently. Even while they go to the extent of defining the hate speech, while to regulate the hate speech, to what extent you can regulate the hate speech, and if hate speech regulation will lead to harm, and even regulating the hate speech also be harmful to the society. Like you say that there is a debate of different variety over the hate speech, but hate speech is basically, it's defined as a torturous, harassing speech, torturous speech, derogatory speech, which offensive speech, and also unpopular point of view, which will meant to harass one community, targeted towards one community or one group of people or one individual. Right. So when we discuss about freedom of speech and expression, the role of hate speech nowadays will come to play a role. And now you also see that United Nations General Assembly has expressed concern over the circulation of hate speech online, and 18 June has also been enumerated as the International Day for Countering the Hate Speech. So that is a step taken at international level to counter the hate speech, and also at our level, we as well as government can also promote inter-racial, inter-religion, intercultural dialogue to counter the hate speech. So freedom of speech and expression is very important, right? Freedom of praise, which we will be discussing later on in another lecture. We talk about freedom of assembly, very important, right? But you see that all this freedom is also subject to reasonable restrictions. So there are certain restrictions which are imposed on right to freedom. Okay, so we talk about freedom of assembly. So you can assemble at one point, and you can also take some collective action. So that is basically freedom of assembly. That your ability to form a collective. So this is also equivalent to freedom of association. Freedom of association, freedom of freedom to form any association, form any group, form an self-help group, any club, any NGOs, any organization. So you have all freedom to create an association, freedom to assemble anywhere, to resist against any action. This is also related to freedom of dissent. The same time, freedom of movement across the country. There's a mobility related freedom. You can move across the country, and freedom to residence and settlement. So everywhere you can reside and settle wherever you want. But again, this is also subject to reasonable restriction. Then you say freedom to profess occupation, trade and business. You can hold any any trade, any business, any occupation in any places across the country. But you see, all the freedoms are subject to reasonable restriction. As I have already told you, that freedom of speech and expression is subject to reasonable restriction. There is self-regulation is followed by media. We talk about freedom of assembly. So you cannot assemble wherever you wish. So there are also certain other regarding action. As I have told you, that liberty can also be viewed from self-regarding action and can be viewed from other regarding action. So when we talk about the other regarding action, so you also need to see that your self-regarding action, what you can do, cannot hamper the other regarding action, the liberty of other human being. Okay, so reasonable restriction in terms of maintaining public order and social harmony. Freedom of association at the same time in terms of public order, harmony. So there are certain clauses on the basis of which reasonable restriction can be imposed upon freedom of right to freedom and all set of right to freedom. And those clauses are defamation, contempt of court, then friendly relation of India with other countries. We also have the public order, not to incite violence and not to incite hatred, etc., etc. Then we actually see that freedom of residence and settlement and occupation, profession in terms of, you see, scheduled areas, 6 scheduled areas, 5 scheduled areas. So there are some restrictions which are also imposed upon the civilians to enter into those areas. So there is a restriction of movement into those areas also. Inner line permit is required. That is also based on the self-representation and self-governing right of the community. Now you see, there are different varieties of rights, as we have already discussed. We have also third generation of rights, right? We have right to self-determination, that is a third generation of rights, collective rights. So their collective rights should not be hampered, and hence government has also taken some actions to to create a reasonable restriction on the freedom, on right to freedom and freedom of movement, freedom to settle, and also freedom of occupation and trade and business. And you see, this right to property has already been amended. Now it is no longer considered as a fundamental right. So we will be discussing about freedom of press and expression later on in another class. Then these are some media reports, and prior to discussing the media report, so we'll also quickly move into those other section of the Indian Constitution. With Article 20 affords protection against arbitrary arrest and detention and punishment, and Article 21 provides that no person shall be deprived of life and personal liberty except according to the procedure established by the law. But that was been changed. That clause has been changed, said that right to life and liberty are inviolable under all circumstances, emergency and no emergency, and that statement was made by 44 Second Amendment. Then also you see that Supreme Court has declared that Indian have fundamental right to education at all levels, and that declaration came in 1992, and Article 22 guarantees protection against arrest and detention. So right to education, this is the very important right. So it is also related to our ability to make choice and take alternative decisions. It is also related to our empowerment. It is a vehicle to our empowerment. We make choice, we make a choice about our well-being. Okay, so it is very important, right? And then we talk about this protection against arrest and detention, which is also very important. A person who is being detained needs to be informed about his detention, and within 24 hours he is to approach a magistrate. So that kind of provision is there in the Constitution. And then we talk about freedom against exploitation. So it is a very important right. At the same time, Article 23, 24 of the Indian Constitution prohibit traffic against human being, beggar, and other similar kind of forced labor. Now, you usually see that when you talk about the forced labor, we also have a legislation that Forced Labor, Bonded Labor Abolition Act. It came in 1976. So, bonded labor were there in India, but also we had some historical um, uh, uh, trace that we can see that Megasthenes from Greek when visited India and wrote Indica that kings during that time banned the bonded labor system. So that was also written in some texts, and so that system was there, but steps were also taken to abolish that bonded labor. And this bonded labor is defined differently, in different region of India. It has got different names. Suppose in Karnataka, Andhra Pradesh, these are called Zetam. In even Madhya Pradesh, it is called, I think, Kavalis, and also Halims. In I think in Madras, then Bhagela. In Hyderabad, it is called Bhagela. So these are known by different names. In Bhagela, then in Bihar, it is known as Kamiyantis. I guess bonded laborers are known as Kamiyantis. So you see, bonded labor. This is also a kind of system where the debitor enter into a contract with the creditor and agree to render his service without payment just because he has taken some loan or economic gain over a period of time, and will render that service for specific or unspecific period, specified and unspecified period. So that bonded labor is a block to the society at the same time, and government has taken some legislations to abolish the bonded labor, and also but many a time it is not strictly implemented, and we also have a certain problem related to this contract labor. Although we have act like Mine Act are there when you talk about the instrument to prevent those inequalities and prevent the violation of human rights, the kind of action government has taken. Then you say that we have Mine Act, we have Factory Act, we have Ways Act, which are implemented. Okay, so there are also like a certain number of employees at times they are not. Enroll their name in the payroll, so they are actually a contract labor, so their names are not answering in the payroll, and they did not get the fringe benefit. Okay, and they did not even avail they can't avail, sorry, they can't get the fringe benefit, and they can't avail the socio-economic benefit. And hence you also see that certain systems are in place to provide them their right and promote their rights. Even there is a need for a strong vigilance committee which can protect their rights. And identification of bonded labor, then also contract labor is very, very important. And properly registering their name and timely and quickly updating their name is also very, very important. Then we see that during British era, one law has been passed, a Slavery Abolition Act, and that was passed in 1833 when India was a colony, British colony, and passing of that act had an influence over India. Also, it has an implication over India. We also had a system. This is called Girmiati system, through which Indians laborers were exported and taken to another country to recruit in different jobs, and especially to African countries, they were taken by the Britishers as a slave. So slave trade was there, and that was a norm at that point of time. So the Slavery Abolition Act 1833 was a very important milestone also to avail the freedom against exploitations. But you see, there are some recorded global slavery index 23 says that around 50 million people were living in modern slavery now, and one in every 160 people in the world are living in slavery now. So that is also another concern for us. So it is not yet being eroded. So in terms of religion also, we get to see their concentration of the slave in the name of religion. Devdasis were also slave in the name of religion here in India. So slave trade is not very peculiar to this country. It is concentrated in other, like, part of the world. So slave trade was there. So different country has adopted different law at a different period of time to abolish the slave. Uh, and we also see that regarding the child labor, so we will have a special session on child labor. So you'll get to learn about child labor. Child labor and child right prevention, child labor prevention act that also came into being 2006, juvenile delinquents, that is also prevention act that also came in 2000. So there are numerous act and legislation that came in against child labor, that also come against freedom, come in this spectrum of right, freedom against exploitation. You see that numerous uh, incidents when child are being engaged in factories, and especially they are engaged in glass factories, mine, and even carpet making in textile factories. And you get to see children with that shrunken cyst, and many a time their heads are also tonsured because they do have the scabies on their head and the skull, and they are also working in a very unhygienic and inhuman conditions. And most of the time you see that they are the one who are the earner for his family. So he needs to worry, and the children, a child needs to worry about his dependent in the family, and he also fall between the 5 to 14. So you see, there are also bureaucrats. They usually come up with the visions that engaging children with any kind of labor activity will also prevent crime. Okay, and also give them feed their stomach. In a way, also prevent starvations. There is also one report that came up. So recent, like that the government amendment in the child right bill. So where we actually get to see that that a child could be engaged in the family enterprises. So that actually led to questions. So what do you mean by family enterprises? The business and the profession which is carried out by the family and the child. The child can also engage after his school hours. So whether it is based on the equality, or whether it can actually make the right to education for the child available, whether the child can play, can also avail recreation or not. So lot of issues actually came up by this very the amendment in the act. So I'll be discussing about it because we have certain media reports. Okay, then moving on to next, we also have right to religion. So right to religion enshrined in Article 25 to 28 and constitute Article 25 constitute equality for all the religions. So we have no state religion in India. So we are a secular um, uh, secular, democratic, socialist country. So we do not have any state religion. And we also see that Indian culture is highly composite. The way we get the reference of Bhakti movement, Sufi movement, Kabir, Guru Nanak are also testament of that composite culture. At the same time, we talk about the Akbar, his Deen Ilahi, and also his Sulhi Kul, peace for all, peace with all, and Deen Ilahi, that fate, equal fate for all. So you see that is also testament of our composite culture at the same time. So we do not have any state religion. So there is a freedom of conscience, freedom of profess, propagate and practice religion. And also we see that every religion, religious domination has given deep freedom to manage their religious affairs in Article 26. Article 27 exempting funds appropriated towards promotion and maintenance of any particular religion from the payment of tax. And Article 28 prohibits religious instruction in any educational institution wholly maintained out of the state fund. But here also there is a condition that educational institution can be maintained by the state fund, and religious instruction can be provided also. But the students, the disciple, pupils are not compelled to take that instruction. Okay, so that is another condition now which is being incorporated, and also you say right to have movable and immovable property in the name of religion, that is also answering in right to religion. So, right to religion is important, and we also have some emphasis on right to religion in one lecture. So, now I'm skipping it now. We have cultural and educational rights, which is very, very important. Article 29 and 30 of Indian Constitution actually deal with the cultural and educational right. So when we talk about this cultural and educational right, it is also important to look into the plural nature and multicultural nature of the country. So India is also a plural country, as I have already told you. Like USA is a multicultural country. India is a plural country. Why we call plural? Because of the multiplicity of religion, multiplicity of caste, multiplicity of classes, languages, ethnicities, etc. So we see that this cultural and educational right has also provided state to work in certain way. It also capacitated state to work in certain way, to also give endorsement to different religion, give endorsement to different ethnicity, different languages. So we contemplate on the salad bowl concept here, a mosaic of all ethnicities, religions, and linguistic communities. So state is also contemplating on the salad bowl and giving endorsement to the diversity. And in order to giving endorsement to the diversity, you see, it is very important to understand what a Kemlika holder about rights. That there are three very important rights. One is that self-determination right. Second one is polyethnic right, and third one is representational right. So these three very rights are very, very essential in terms of cultural and educational rights. Basically, those three very rights will also fall into this cultural and educational right. What those section of article said is that Article 29 said that there should be protection to any section of citizens to conserve their distinct language, script, and culture. And Article 29 2 prohibits the discrimination between citizens in state-funded educational institute on the grounds of any religion, race, caste, language, or any of them. Then you see Article 30 provides minorities based on religion and language that shall have the right to establish educational institution of their choice. So you see that all three variety of conditions fall under the self uh, determination right, polyethnic right, and self representation right. So, the right to self determination is very important. We have already told you that it is about your right to decide the political organization, right to pursue socio-economic political development. So, right to pursue a community's right, community's collective right to pursue socio-economic political development and also pursue political organization is known as self-determination right. Okay, then also we have polyethnic right, that ethnic community, certain rights are available to ethnic community. Okay, so apart from their decision to have their own government, suppose in six schedule areas, fifth schedule areas, there are autonomous regions, autonomous councils are there. So governor is the one who rule over those countries, fall under the sixth schedule tribal areas, basically those like the fifth schedule areas. So governor usually take the decision, and there are autonomous regions, autonomous countries, they govern those areas. So that is a part of self-governance right. So they have their right to decide how they run the system. No, apart from that, right to run the system means everything. You see this right to run the employment, right to run like public institutions, about educational institution. So they do have right. Huh. So they will directly communicate to government. Governor has a rule over it, and autonomous regions, autonomous council will take all the decisions regarding their availing of the rights, availing of those rights. And then we see that polyethnic right is one that right will say that there are certain exemptions should be provided to certain communities in one country uh, based on their very ascriptive identity. In the sense that you see, Punjabis are exempted to wearing helmet, so that is a polyethnic right. So we cannot even impose them wearing helmet. Okay, so there are certain communities they should be exempted even from slaughtering cows. Jews and Muslim communities should be exempted from slaughtering cows. So any kind of, so in the sense that they should have that right to slaughter the cows. They exempted from the repercussion of slaughtering cows. Exempted from the repercussion. So it is also based on their that cultural specific norms. And also you see, like the way we have prevailed upon the rights of wearing pug and exemption of wearing helmet for, you see, uh, 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 Sikh community. That is equivalent to polyethnic rights. Certain rights should be available based on their very ascriptive identity to understand their sentiment. Okay, this is important. And then we talk about the representational right. Representational right, which is important to get equal representation in the institution, in educational institution, in public employment, in even offices, in parliament, in political life, in social life. So it's very, very important that representational right. And representational right could be availed through certain legislation like positive discrimination. We talk about affirmative action. We talk about positive discrimination. Reservation is also one kind of representational right. It is through which that representation is being availed. Talk about some affirmative action government is being taken, that is a free fooding, lodging are being availed to one section of the community based on caste, based on their ascriptive identity, is also a kind of representational right, which is very, very important to create an egalitarian society and also to maintain the multicultural nature of the state. So it's very, very important to maintain the multicultural nature of the state, because the very demand for rights emanates from the plural nature of India, as I have already discussed. So it's important to endorse the rights of different communities. It's very, very important. Now the one step has been taken, the Drupadi, Assami and Bengali become the Drupadi language. That is also to certain extent self. You see, that comes under the multicultural framework, and also cultural and educational right. Okay, and then uh, we see that there are some other example I'd like to give you. Uh, um, in Europe, even in Australia, you said there is gradual Asianization. They have recognized that gradual Asianization. In Canada, the French-speaking people and English-speaking people are given equal status, and also along with the Inuit people. Maori is also an Aboriginal community in New Zealand. They are also given equal status by view of those representational right, polyethnic right, and you see, as I have already told you, this is called the governance right. Okay, so it is important. Then, as I have already told you, some of the unenumerated fundamental rights, these are available to the citizen of India through judicial decisions, but these are not enumerated. These are not mentioned in the constitution, but these are available, right? You see that right to travel, right to privacy, right against solitary confinement, right to human dignity, right to free legal aid, right to speedy trial, right against handcuffing, right against delayed execution, right against custodial violence, right to shelter, right to freedom of press, right to know, right to compensation, right to release and rehabilitation of bonded labor, right of inmates of protection homes, right of not to be imprisoned for inability to fulfill a contractual obligation. So these are certain rights which are not enumerated in the fundamental law of the land, in the constitution, but by judicial decision these rights are being enshrined, and these rights are already mentioned in the covenant of civil and political, is it, rights. And then the last of we are actually end of this of the lecture. So at last we have right to constitutional remedy. So Article 32 empowers the Supreme Court to issue direction and a writ, about which Motilal Nehru report, we get to find right to issue writ and right to get the writ, at least the habeas corpus, right to bring the body is very very important. Certain writs are there which can be issued, and also you see that whenever rights are being suspended, we can move to court, so making the rights justiciable. As I have already told you that fundamental rights are justiciable, and we can also move to court whenever rights are being violated. Our rights are being violated. So, right to constitutional remedy, actually speaking about those orders and the writs in the nature of habeas corpus, mandamus, prohibition, certiorari, and quo warranto, and whichever be appropriate for the enforcement of any fundamental right. Now, habeas corpus means bring the body, so order a person to come to court. Mandamus is basically an order given to one public undertaking or any public organization to do his duty. Okay, to do his duty, suppose appointment letter is being sent but is not being called, then person can also go to court to seek remedy of his right, then can also order, court can order to do his duty, do that public organization, do this duty. Then prohibition is also one. Prohibition, co-warrant and certiorari are of same variety. It is also prohibit the Supreme Court can prohibit the High Court of any decisions which any decision which is not in allegiance to the greater interest of the society. Basically, they prohibit certain decision of the lower court, and also we have this quo warranto that is also given, you say, more power to even uh, the High Court to extend their jurisdictions, and charterary that also that read has provided the right of the court to review the decision of the lower court. Okay, so like this way we have certain rights. I'm going to end my lecture today.